The following presentation is on business torts and product liability, which in the current textbook that I'm using is Chapter 7. And I'm recording this presentation primarily because the students this semester have just finished taking an exam on Chapters 1 through 6. And probably right now they're pretty much brain dead, and the chances of them having the time to read Chapter 7 in the between exam 1 and the next class meeting, the chances are slim and none. So rather than put them through the torture of having to just sit and listen in a classroom, I can torture them with this recording. Now, hopefully it won't be torture. They can sit back and relax and watch this presentation at their leisure, and that gives them plenty of time to read the chapter. All right, since we've just finished covering an entire chapter on torts, there's a limit to what I need to do as far as giving you a background in tort law. We've covered tort law. And what this chapter does is just takes the subject of tort law and then applies it to product liability and some business situations that we will cover in the course of the next 20 or 30 minutes. The references I'm going to make to handouts are to the handout that gives you a checklist of the topics for Chapter 7, and I've also posted a handout that summarizes fraud and misrepresentation. I have those two items with me here, and I'll be making reference to those outlines during this presentation. The first item that I have on your checklist is fraud and misrepresentation. The handout, where it breaks it down into its component parts, is worth taking a look at. At the top it says fraud versus misrepresentation, general rules. What you're looking at here are two separate categories of misrepresentation. If the misrepresentation is intentional, generally what you're talking about is an action based on fraud. If the individual has innocently misrepresented something, still misleading the other party, but it was an innocent misrepresentation, that's not as egregious, that is not as bad as the tort of fraud. If you want to think of a good example of fraud without even having to analyze all the elements, just think of the times that you've heard of people going to buy a used car, and the salesperson may tell them things like, "We just checked the brakes are in good shape. This car has just had a 27-point inspection and is in excellent condition." Those sorts of comments sometimes are made by the salesperson, and then the unsuspecting buyer gets home and realizes that the brakes don't work, or in some cases, at least one case that I've known of in recent years, one of my former students bought a car and found out, unfortunately for him, that the brakes didn't work before he even got home. And that ended up in a pretty nasty situation, but thankfully no tragedy ensued. So fraud takes many shapes and forms, but again, fraud is where somebody generally has either they knew that the statement was untrue, or just flat out lied. That's typically what you're looking at here. Let's call it what it is. It's typically going to be where the individual who made a statement that you relied on knew that it was untrue, and that statement, when you relied on it, it induced you to proceed with the sale or whatever the contract involved. And your reliance on that material misrepresentation of a material fact is what brings about this tort of fraud. And I've broken the elements down. Actually, the book has a similar breakdown. I compared what's in the book with what I have provided over the years to students based on general rules of law with respect to fraud, and they pretty closely parallel each other. I didn't see anything that was substantively different. So you can either use what's in the book what I would do is read what's in the book, and that will explain the 7 elements that I've addressed on your handout. Misrepresentation, as I noted on the handout, is often called innocent misrepresentation. Just know that even by remaining silent, you can misrepresent something. And I've got 3 situations outlined on the handout where even a person's silence might mislead you and bring about this cause of action for misrepresentation. You would think that everybody would understand what a material fact is, but just to be sure that there's no misunderstanding, I've broken that down at the bottom of the page into its component parts, so you understand generally what the law recognizes as a material fact. So that's the big picture on that. Again, fraud takes many forms, and it's probably something that you've seen a time or two in your life already. Unfortunately, it's something that happens often in a business environment. Misrepresentation sometimes can take other forms in addition to this breakdown that I've got on this handout. I've seen an individual, there's a case that occurred a few years ago where a supervisor had an employee come to him and ask him about a certain medical procedure that the employee's wife was going to have, and he asked his supervisor, "Does our insurance cover this?" And the supervisor said, "Well, yes, my wife just had that surgery performed last year and our insurance covered it fully, no problem." Well, what the supervisor didn't know is that their medical insurance had changed over the last year, and that procedure was no longer allowed under their current insurance, and the employee who relied on that statement had his wife go ahead and have the medical procedure. It was a very expensive procedure, something like about $60,000 worth of surgery. The employee who relied on that statement, even though there was no intentional misleading on the part of the supervisor, the employee turned around and sued both the employee and the employer for the tort of misrepresentation, and he prevailed. It was, I think, somewhere around $60,000 to $80,000 that he won from the employer. Certainly you want to sue the individual wrongdoer, but again, you're going after the deep pocket. The supervisor may not have 80 grand to pay up immediately, so you go after the employer, as this individual did, and he recovered fully for the amount that his wife had paid out for the surgery. So that wasn't fraud, that was just an innocent misrepresentation. Next on the checklist, I've got several torts listed here, all of which are very similar. You've got a case on page, I think it was 171. Yes, 171, down at the bottom of the page. And this is just an example of where a court took a very broad definition of what prospective contractual relations are. That's the third tort listed. These are all very similar. Tennessee recognizes torts similar to these others that I've listed here specifically, and they appear to be the same tort. I've read a few cases where the courts in Tennessee refer to interference with a business relationship, and it doesn't matter whether a contract is involved or not. And then in another case, they took that same theory and referred to the tort as interference with employment. So if the contractual relationship is one dealing with employment, it appears that Tennessee courts use the term interference with employment. I just want you to know that these torts exist, so that where somebody, I've heard of this happening numerous times, since employment law is what I deal with more than anything else. I've had people tell me about where some coworker, typically some jealous coworker, has maliciously interfered with their employment relationship. Uh, typically it's a coworker who's jealous, wanting a promotion. They're afraid you're going to get it, so they go to the boss and say some terrible things to keep you from getting the job. True, it may constitute defamation as well, but you also have this tort of interference with employment. And I believe I noted on the handout that I posted on D2L with respect to Tennessee cases that a good case to remember, just to give you an example of how Tennessee applies this concept. Lane Kiffin, who people in Tennessee, I had moved here to Johnson City, I think it was summer of '09, and I can't remember if Lane Kiffin had left or not, but I just remember he was the guy that people in this area loved to hate, because he came to UT, and I don't know all the history, but generally he came to the University of Tennessee, and he was going to be their greatest gift ever. He was going to do wonderful things at UT, and he gave them the impression that he was there for a long, long time. And 1 year later he quit to go to USC and just kind of left UT hanging and swinging in the breeze. And so he goes to USC. What he did when he went out there to help build his staff, he approached a coach with the Tennessee Titans. I don't remember the coach's name, but he approached a coach and encouraged that coach to leave the Tennessee Titans and join him at USC. And the Titans turned around and sued Lane Kiffin for interference with business relationship, particularly there. There was a contract involved, and it appears again from what the terms that the judges seem to use in Tennessee that could also be referred to as interference with employment, but it gave the Tennessee Titans a cause of action against Lane Kiffin for interfering with a business relationship with one of their coaches. Just know in general what those torts are. There's coverage of that material in the textbook at the beginning of the chapters, so just take a look at that and you'll be in good shape just to know generally what those torts look like. The next subject area in the chapter deals with product liability. There are just some general things that you should keep in mind. For example, if I'm injured by product, let's say I bought the product at Ace Hardware, historically, in order for me to recover from the manufacturer, the courts required that there be a contractual relationship between me and the manufacturer, which is unrealistic in today's business environment. And over a course of time, this contractual relationship requirement has been dropped. This is what's referred to in the chapter as privity of contract. And privity of contract, meaning a contractual relationship, is not required between the injured party and the manufacturer, not today. The various theories that may be used, the first one I have on your list is negligence. And at this stage in the game, since we've just spent several hours looking at the tort of negligence and the defenses to negligence, I'm not going to go back over all of that. At a minimum, that the tort of negligence requires that an injured party prove that the defendant had a duty of care that was owed to the individual who was injured. So you've got to prove duty, breach of that duty. You've got to prove causation and damages. And remember, the damages can take several different forms. They can be economic in nature, they can be physical, or they can be mental in nature. So 3 different types of damages are what you're looking for the tort of negligence. Any one of those 3 can constitute that fourth element of damages that's required to recover for negligence. Proving negligence sometimes can be very difficult. It can take expert witnesses to show what the duty of care is. Remember, generally the duty of care is to act as an ordinary, reasonable, prudent person under the circumstances. So if it's product liability, you've got to take what the current state of technology is, how much we know about the products and the components that make up those products, and then you ask yourself, what would an ordinary, reasonable, prudent manufacturer do? To what extent must they exercise reasonable care? Exactly what is reasonable care? And rather than get into all that, there are other theories that can be used. So negligence is one, and again, acknowledging that can be very difficult to prove sometimes because of having to prove particularly what the duty is, and then did they in fact breach that duty. We've got these other theories to look at. You've got strict liability, and these are all addressed in the chapter, so it's nothing that you can't go back and pick up in the book. But you've got strict liability both in contract and tort. So you've got contracts theories and tort theories where strict liability is available. The contracts theories, you've got implied warranty of safety that are in the chapter. You've got express warranties, and that's typically going to be in the form of advertisements where something has expressly been stated concerning the nature of a product that's being sold. The tort theories, typically, again, you're looking at something like misrepresentation. But pay particular attention on, and I don't have the page number, but there are 4 scenarios that typically arise under tort law on page 180. That appears to be where that material begins, where you've got manufacturing defects, failure to warn. This is begins on 181. The 4 scenarios you've got situations where you have defects in the manufacture of the product, situations where a manufacturer fails to warn of certain dangers. The third one is design defects, and then last, where there are unknown hazards. Be generally familiar with each of these scenarios, and there are some very interesting cases that have occurred over the past 15 or 20 years that I've at least had reason to pay attention to this particular area of business law. Let me just give you some examples. You can think about some of these, and these are just general product liability lawsuits. The areas that are most common as far as the types of products, toys are at the top of the list. So you've got toys, medications, medical devices, electronics, food products, vehicles, motorcycles, boats, baby products, and then the list tapers off for everything from power tools, ladders, clothing, bedding, sporting goods. It's incredible just how dangerous some of these products are that are put on the market, and just what the courts expect employers to do or manufacturers to do with respect to things like warning labels. So be familiar with these different scenarios. You've got a couple of cases in the book that I've noted here. The Parrish case on 181 would be worth taking a look at, as well as the case, the Tempte, I guess is the way they pronounce it, Tempte Industries on 184, dealing with a design defect. Just take a look at those cases. It'll help give you some idea of the analytical process that the courts go through in determining liability. The case on 181 deals with a trampoline, and it'll give you an idea of just how thorough manufacturers have to be with their efforts to warn customers. In that case, an individual had jumped on a backyard trampoline, did a somersault and landed on his head and was rendered a quadriplegic as a result of landing on his head. So, depending on the age, I don't know if this was the individual suing or the parents. It says he sued, so it's probably if it was a child, the parents are suing on his behalf. But regardless, the injured party is suing, and the court draws attention to all the warnings that this trampoline manufacturer had actually employed. You're told in the facts that warnings are placed permanently on the pad of the trampoline, and specifically what the warning says. You're told in the facts that the warning said specifically, do not land on head or neck. You're also told in the warning that paralysis or death can result even if you land in the middle of the trampoline mat. That's one that ought to concern every parent right there before you put a trampoline up for your kids. Next, it says to reduce the chance of landing on your head or neck, do not do somersaults. And of course, that's what this person had done. So this was a warning on the actual trampoline itself. The court notes that the warnings also include nationally recognized warning symbols cautioning against those activities. Also, there are warnings on each of the 8 legs of the trampoline. There are also warnings sewn onto the trampoline bed itself. Also, there is a warning sign for the owner to affix to the trampoline. And in the owner's manual, it also contains the warnings that were found on the trampoline. In spite of all these warnings, and in spite of the fact that the manufacturer of the netting that was put around the trampoline, they also had plenty of warnings. In spite of all these warnings, the family still sued, or the injured party still sued to recover. So what you see in today's environment is what certainly to a layperson would appear to be overdoing it. And even in my opinion, in some cases, manufacturers have overdone it as far as warning labels. Best example I can give you of overdoing it is in my son's car. He's got a sun shield that he'll sometimes put up in the windshield of the car. And we had one, I don't think we've still got it, but we had one that when you opened it up and put it up in the windshield of the car, it said on the inside, do not operate vehicle with sun shield and windshield. It's like, who would do that? But apparently there are those who would leave the sunscreen up in the windshield and start the car up and drive off. So warning labels, I guess in the opinion of most manufacturers, when you see all the lawsuits that take place, you can't overdo it as far as providing warning labels. I've got some that I've had brought to my attention in recent years, just to give you an example. And again, these would seem to be overdoing it, but apparently the manufacturer felt that it was appropriate. On a sleep aid, this is a sleep aid called Nytol, N-Y-T-O-L. There's a warning on the label that says, guess what? May cause drowsiness. No, you're kidding me. So a sleep aid warning you that it may cause drowsiness. Here's one on a hairdryer sold by Sears. Now, they may have taken these off by now. This is roughly 4 or 5 years old, but there's a hairdryer that was sold at Sears. Someone noticed a warning label that says, do not use while sleeping. Apparently, folks have purchased hairdryers and on a cold winter night turn the hairdryer on maybe to keep them warm at night. But at any rate, don't use a hairdryer while sleeping. Not a good idea, and this warning cautions against that. And here's another one by a manufacturer of a clothes iron. It says, do not iron clothes on body. That's a good one to keep in mind. So they're telling you, take your clothes off before you put this hot iron on your shirt or slacks. All right, so again, 4 scenarios, just be generally familiar with them. Again, that's defect in the manufacture of a product, design defects, failure to warn of dangers, and last, where there are unknown hazards. Things like years ago, asbestos was used for so many products, used for insulation in homes, used on brake pads of automobiles, and at the time that this product was being used, people didn't know of all the potential hazards. So that was an unknown hazard associated with asbestos, and certainly over the last couple of decades with all the litigation, manufacturers don't use asbestos nearly as much as they used to because of all the negative effects that material can bring about. If I recall correctly, cancer is one of them, lung cancer in particular. All right, so we've got those are the various theories. You just need to be generally familiar with what those theories are. And it's worth noting, too, to keep in mind that the law can vary greatly from state to state, just as we acknowledged in Chapter 6 on torts. Now, that body of law could vary greatly. The law, as it gets applied to product liability, can vary greatly from one state to another. Okay, the defenses to these various theories. Some of these we've looked at previously. For example, the defense of assumption of risk, that has been addressed previously. Misuse is certainly another defense. If you develop a product or a tool for a particular use and somebody uses it for something else that is obviously an inappropriate use, then you've got the defense of misuse that could come to your aid if you're the manufacturer. Assumption of risk, remember from the last chapter, generally there are two requirements. Nothing's changed with respect to the requirements for assumption of risk. The requirements are that the risk that one assumes has to be both knowing and voluntary. So I can assume it only if it's knowing and voluntary. I must know about the risk and voluntarily act, or in this case, use the product in the face of that known risk. A classic case there that would help keep that defense in mind. A lady was staying with a friend of hers. And she was staying at the friend's house overnight. The lady asked her friend, "Can I use your hairdryer?" And the homeowner said, "Sure, you can use it, but be careful." And she turned it on so the lady, her friend, could see the problem with it. She turned the hairdryer on, the homeowner did, and the hairdryer shot sparks out of it. And her overnight guest put the hairdryer to her head anyway, and unfortunately for her, she had hairspray in her hair. And of course, the thing shooting sparks, you turn it up to your head and it's shooting the sparks. Her head exploded into flames, and she kind of did a little Michael Jackson thing there. I think that happened, something like that happened to him in a Pepsi commercial a few years ago. But anyway, the lady sued, and the defense was, and appropriately was, assumption of risk. You knew about the defect, you knew about the product shooting sparks out of it, and you used it anyway. So the risk was both knowing and voluntarily assumed. All right, next defense, sophisticated user. Generally, what all that defense says is that I don't have a duty to warn a person if they know or should know of the dangers. So if I'm selling something to someone who's an expert with this particular product, and the danger is one that, by them being a sophisticated user, they would know about or should know about, then I don't have a duty to warn them. The next defense, and all of these are in the book. I think they're in the order. I don't think they've rearranged them. I'm pretty sure it's in the order that I've listed them on your handout. The bulk supplier doctrine, that just says that if I'm the supplier, my duty to warn is discharged if I provide instructions to the party who's distributing this particular item. So it's, again, my duty is discharged by simply just telling the distributor, providing instructions to the distributor, and then it's up to the distributor to disseminate that information to the consumer. The last item that's recognized as a defense is where you have an ultra-hazardous activity. And again, all of these are addressed in the chapter, and that one is also addressed in here on page 188. There's one item that I overlooked. I think I have it addressed just before defenses, and I want to call your attention to the joint and several liability concept. Essentially, and that's, I did look that one up, that's on page 185. It just says that if I'm going to sue, let's say that it's like I believe it was the McPherson case in the book, where the issue was one of defective brakes. I could sue the manufacturer, I could sue the seller, I could sue the company who made the brakes. I might sue the company that provided the component parts to the brakes. I don't know exactly who in there was negligent, but somebody was careless with the brake system because the brakes didn't work on the automobile. I can sue all of those individuals, and I can recover against any one of them. And then what the law says is that with respect to the injured party versus the people who put that product on the market, the ones who should suffer would be those individuals, the manufacturers that put the product on the market, as opposed to me, the injured party. I shouldn't suffer having to figure out which one of these was negligent or the most negligent. The law says I can recover against any one of them, and then they have to fight it out amongst themselves to figure out who really is going to pay and who was at fault. So typically this concept is going to come into play when two or more parties may be liable, and it just makes it a little easier on the plaintiff to recover. Certainly they're going to want to go after the party with the deepest pockets. That's who they're going to get their award from, and then let everybody else figure out who should pay the most, if any at all. All right, again, that's the concept of joint and several liability, and I've made myself a note that it was on 185. Yes, page 185. You can either remember it by the description I've given or read what's on page 185. We're saying pretty much the same thing. All right, hopefully this information will help, even if you're in a class where I've already covered the material in class. Certainly it wouldn't hurt to look back at this as a refresher, although I don't think it's necessary. This chapter is one of the easier chapters in the book, and typically one good reading will take care of all you need to know with respect to this material.